This summary is provided to assist in understanding the court's decision. It does not form part of the reasons for the decision. The full judgment of the court is the only authoritative document. You will find a link in the description to the full judgment. In the High Court of Justice, Queen's Bench Division Administrative Court. Before, Lord Justice Bin and Mr. Justice Garnham. R. Gardner and Harris, v. Secretary of State for Health and Social Care and others. Decision of the High Court, Lord Justice Bin and Mr. Justice Garnham, the 27th of April 2022. About 20,000 residents of care homes in England died of COVID-19 during the first wave of the pandemic in 2020. Two of them were Michael Gibson, father of the first claimant Dr. Kathy Gardner, and Donald Harris, father of the second claimant, Ms. Faye Harris. Mr. Gibson died in a care home in Oxfordshire on the 3rd of April 2020, Mr. Harris in a care home in Hampshire on the 1st of May 2020. Dr. Gardner and Ms. Harris brought a claim for judicial review against the Secretary of State for Health and Social Care, NHS England, and Public Health England. They alleged that certain policy documents issued by the defendants during the relevant period, and the policy decisions recorded in those documents, constituted breaches of their father's rights under the European Convention on Human Rights, or alternatively were irrational as a matter of domestic common law. The claimants did not claim compensation, but sought appropriate declarations by the court. In its judgment, the High Court described the case as an important and legitimate claim. The judges said that they were not conducting an inquest concerning the deaths of Mr. Gibson and Mr. Harris alone. The claimants' fathers were put forward as representatives of many other residents of care homes who died during the first wave of the pandemic. On the other hand, the case was not a public inquiry but a judicial review. As is usual in judicial reviews, no oral evidence was called. On the 15th of December 2021, the Right Honourable Baroness Howlett DBE, former Lady Justice of Appeal, was appointed to conduct a public inquiry under the Inquiries Act 2005 to examine the UK's preparedness for and response to the COVID-19 pandemic, and to learn lessons for the future. One of the many topics mentioned in Baroness Howlett's draft terms of reference is the management of the pandemic in care homes and other care settings, including infection prevention and control, the transfer of residents to or from homes, treatment and care of residents, restrictions on visiting, and changes to inspections. The establishment of her inquiry does not, however, affect the present claim. In their judgment handed down today, Lord Justice Bin and Mr. Justice Garnham found that the decisions of the Secretary of State for Health and Social Care to make and maintain a series of policies contained in documents issued on the 17th and the 19th of March and the 2nd of April 2020 were unlawful because the drafters of those documents failed to take into account the risk to elderly and vulnerable residents from non-symptomatic transmission, which had been highlighted by, among others, Sir Patrick Vowlance in a radio interview as early as the 13th of March. Non-symptomatic transmission would mean that one elderly patient moved from hospital to a care home could infect other residents before manifesting symptoms, or even without ever manifesting symptoms. The judges found that it was irrational for the EWHC not to have advised until mid-April 2020 that where an asymptomatic patient, other than one who had tested negative for COVID-19, was admitted to a care home, he or she should, so far as practicable, be kept apart from other residents for 14 days. The court dismissed the other aspects of the case brought by the claimants, including claims under Articles 2 and 8 of the European Convention on Human Rights, and a claim against NHS England, which is legally distinct from the Secretary of State. Conclusions. The claims under the Human Rights Act 1998 are dismissed. The common law claim succeeds against the Secretary of State and Public Health England in respect of both the March discharge policy and April admissions guidance documents. To this extent, the policy set out in each document was irrational in failing to advise that where an asymptomatic patient, other than one who had tested negative, was admitted to a care home, he or she should, so far as practicable, be kept apart from other residents for 14 days. The claim against NHS England is dismissed.